understand. I am a St. Lucia, no matter how far I go. Thank God that I am a St. Lucian, and I come from the land of sun. Thank God for the Helen of the West, simply beautiful and blessed. Let me see your hands up, for I am no that. Hands up if you're proud of where you're from. Hands up, cause all of we are one. Hands up if you are St. Lucia.
Good evening. Thank you for joining us for another discourse on the Constitution to help to educate members of the public on the basics of the Constitution. There is a doctrine of constitutional law called separation of powers, under which the three branches of governmental authority, the executive, consisting of the Prime Minister and the Cabinet, the legislature, consisting of the Parliament, and the judiciary, consisting of the judges headed by the Chief Justice, are kept separate to prevent the abuse of power. Each branch is given certain powers in order to provide checks and balances for the other branches, so that each does not infringe the other's constitutionally vested powers. Today I wish to focus on the legislature, which is another name for Parliament. Our guests today are knowledgeable in this area because of the functions in which they serve or have served. I will introduce the ladies first. First of all, I introduce the Speaker of the House, the Honorable Leonne Theodore-John. She is at the extreme right. She's an attorney at law by profession, and she has the distinction of being one of only two people, both being St. Lucians, to have served in both the position of Speaker of the House and President of the Senate. Incidentally, the other person to have served in both capacities is Mrs. Rosemary Mathery, now Parliamentary Commissioner. My second panelist to my immediate right is Ms. Gillian Vidal-Jules, also an attorney at law, who is the Director of Legislative Drafting in St. Lucia. And our third panelist is the well-known Mr. Claudius Francis, a popular radio personality and insurance executive who served as President of the Senate between 2012 and 2016. Thank you all for joining us for this important discourse. Now, Article 23 of the Constitution provides that there shall be a Parliament of St. Lucia, which shall consist of Her Majesty, a Senate, and a House of Assembly. By now, I think that all St. Lucians know that Her Excellency, the Governor General, is Her Majesty's representative in St. Lucia. So I will not dwell on that aspect of the Parliament right now, but will concentrate instead on the other two limbs. Mr. Francis, if I may start with you. Can you tell us about the Senate? What is the Senate? Who comprises the Senate, and how are senators appointed?
Thank you, Madam Moderator. Curiously, it is called the Upper House. That's for another show. Section 24 of the Constitution establishes the number of senators, and it states that 6 shall be appointed on the advice of the Prime Minister, 3 on the advice of the Leader of the Opposition, and 2 by Her Excellency, acting in her own deliberate judgment after consultation with the trade unions, social partners, civil society, etc.
So what qualifications do you need to be a senator?
Interestingly, not much. And that the qualifications would come under Section 25 of the Constitution, where the first qualification is that you must be a Commonwealth citizen. And that's interesting, not just a St. Lucian citizen, but any member of the Commonwealth may be a senator. That person has to reside in St. Lucia for a minimum period of 5 years before being appointed a senator. And thirdly, these are the only 3 qualifications, that person must be sufficiently fluent in the English language to be able to debate in the parliament. These are the only three. And of course, the age prescription, which previously, when the Constitution was adopted in 1978, became effective in 79, was 30 years of age. But there was a constitutional amendment in 1979-80, because the person whom they wished to be education minister was just then 29 years old, so there was an amendment to the Constitution.
Okay. So are there any prohibitions in the Constitution against anyone becoming a senator?
Quite a few, actually, quite a few. You must not swear allegiance to a foreign country. You can't be a minister of religion except if you are appointed by the Governor General. So the Prime Minister could not appoint a minister of religion, neither can the opposition leader. You can't be an undischarged bankrupt within the Commonwealth, not just within St. Lucia, but within the Commonwealth. If you're certified insane, if you're under a penalty of death, if you're under a sentence of imprisonment of 12 months or more, and interestingly, that applies even though the sentence is suspended. And if you're guilty of an election offense, which is a separate kind of offense, and if the election offense, you're disqualified for 5 years from the date from your release from prison. And finally, if you're a police officer.
Okay. Now, Mr. Francis, you were president of the Senate. How is the president elected? Or is it that the president is selected?
The president is elected by the 11 senators at the first sitting of Parliament. That election is conducted by the Clerk of Parliament. In our system, the election takes place absent of the person who has been nominated to be president. So in advance, the leader of government business and the leader of opposition business come together and agree a president. The president remains in the lounge. He is told after his election that he's elected, and he comes in and presides over the Senate.
Okay, thank you. Now we will go to Madam Speaker. Can you tell us what the expression the House signifies?
In St. Lucia, we have a bicameral legislature, which means it consists of an upper house, the Senate, and a lower house. The House of Assembly is actually referred to in short as the House. And this is where you have by and large, it consists of mainly, but not only, the 17, as in the case of St. Lucia, elected parliamentary representatives.
Very well. Now, well, I suppose it goes without saying, I shouldn't ask what are the qualifications, because that should speak for itself. But I guess I'll ask you that. What are the qualifications to be a member of the House?
Well, first and foremost, you have to be elected through the ballot box. As former President Francis said, I think you need to be a citizen of St. Lucia of 21 years. You must have either been born in St. Lucia or domicile or resident in St. Lucia, at least at the date of your nomination, or having born elsewhere, has resided in St. Lucia for a period of 12 months immediately before that date upon your nomination. And you have to be able to speak English fluently and express yourself fluently. So a proficiency of English qualifies you as well.
Very well.
But I guess in the case of the House of Assembly, you come there through an election process.
Yes. Well, are there any disqualifications provided by the Constitution?
Well, unlike the qualifications, the disqualifications are many. So under Section 32 of the Constitution, you would be disqualified if you have sworn allegiance to any other adherence to any foreign power or state. If you're a minister of religion, you cannot be an elected member of the House. If you are an undischarged bankrupt, as the same case with the senator, with the senators, having been a judge or otherwise declared bankrupt, and any other law within the Commonwealth as well. A person who's certified insane, the same way, you cannot be. If you have been a convicted felon and or you are under sentence, a death sentence has been imposed upon you, any part within the Commonwealth, not just St. Lucia. If you were convicted, that conviction must have been spent, or you would have carried out your conviction, and no more than 7 years would have, no less than 7 years should elapse before you can be elected to serve. And if you are a member of if you are a senator, you cannot serve in the lower house. If you are a member of certain commissions, such as the Electoral Commission, you cannot serve in the Parliament of St. Lucia. Okay. So under Section 32 of the Constitution Order of St. Lucia, there are many qualities which would disqualify you to serve as a member of the House of Assembly.
I detect that there's a little difference between the House and the Senate in terms of the convictions and how long after you can be eligible to be a member.
Yes, in that, whereas with the Senate it is 5 years, under the House of Assembly it is 7 years.
Okay.
That is having served a conviction.
There's
Yes.
also a slight difference. In the Senate, you don't have to be a citizen of St. Lucia. In the House, you must be a citizen of St. Lucia.
Okay,
Yes,
very well.
I think I alluded to that.
Yeah.
Yes.
Yes. And Ms. Theodore-John, what is the tenure of a member of the House?
Until the next dissolution of Parliament. So, for example, one may be an elected member. We know that our elections is generally within 5 years, but sometimes it is short of 5 years, a little over 5 years it could be, but by and large 5 years. However, once the House is dissolved, and most times it is in preparation for general elections, the tenure of a member of the House comes at an end.
Okay. Well, now can we move on so that you can tell us about your position as Speaker? What qualification is required for your job? Must you be an attorney at law?
Not at all. In terms of the Speaker of the House of Assembly, just borrowing from the Trinidad situation, which has a very active and active parliament, their qualifications simply states that you must have the chief characteristics being authority, strange enough, and impartiality. However, the Speaker, so in terms of, I think it augurs well if you have, for me, my background being an attorney at law, one equates that to being very vocal perhaps and stuff. So by nature, I think lots of people know me to be a talker.
All right. And what does your position as Speaker require you to do in general?
In St. Lucia, the Speaker, in his or her absence, the Deputy Speaker, presides over each sitting of the House of Assembly, acts as chairman or chairperson in committee stages of a bill, and enforces and observes all the rules for preserving order in the proceedings. As a result, my role, I have to maintain order, enforce the rules as is necessary, interpret standing orders and practices of the House, I deal with points of order and give rulings when called upon to do so. The Speaker is considered to be the guardian of the privileges of the members of the House, and whose chief characteristics, as I said earlier, requires her to be to have authority and impartiality. The Speaker also is responsible for the management and general administration of the House of Assembly.
Okay. Now, there was a recent sitting of the House of Parliament, House of Assembly, at which it is alleged that you asked two members of Parliament, one being the Honorable Prime Minister, to take their seat, and another member of Parliament allegedly complained about being picked on. Now, I suspect some of those who were watching or hearing about it might have taken that out of context. So I want to ask you, what is your role in the debate process, and what would cause you as Speaker to interrupt a member during his or her presentation, or ask any member of the House to take his or her seat?
My role, as I said earlier on, as Speaker requires me to conduct the affairs in terms of the proceedings of the House. Incidentally, I am not required as Speaker to participate in the debate at all. And so I must conduct. So I'm basically presiding and conducting and ensuring that the House, the debate in the House is conducted in a manner befitting of or in accordance with the standing orders of the House. The House of Assembly has its standing orders, or, for want of a better word, its rules, which guides us to the conduct, behavior of the members of the House. And so, also, during a debate, there are various stages, and there are manners in which bills are presented or motions are moved, and all of that requires strict adherence to formality, as it were. And if, for example, in the presentation of a bill, so I will give an example. If a bill is presented on the order paper, which is your agenda for the House sitting for the day, for want of a better word, and the order paper, one of the bills down for debate, if there is an asterisk on it boils down to that, on the order paper, and the bill is being presented for first reading, the asterisk signifies that this bill will go through, or will be expected to go through its remaining stages at this sitting. And so this sitting, because there are rules in the standing orders of the House, which says that between the first reading and the second reading, there are days set between the first and the second reading. In order for the bill to go through all of its stages, there are processes. And one such process or stage is that you would need to suspend a particular standing order which provides for the number of days between the first and the second reading in order for that bill, the second reading, to be presented in the House on that day. And so one cannot present a bill for second reading unless you do the suspension first. So it is more procedural and following procedures that there are stages, as it were, that we have to strictly adhere to. If not, there can be chaos. On the issue of asking members to take their seats, on the day in question, there were 3 interjections by me, 3 requests of members to take their seats. If members are required on first being elected a member of the House, you are given your standing orders. Your standing orders guide you, as I said, your rules. And if you have to know your rules. If you want to stand on a point of order, I've explained, members are to direct me immediately as to what order they're standing on.
Can I just stick a pin to tell you that I wasn't asking you necessarily to explain what happened, but just to ask you what would cause you to interrupt a member. But we're going to a break right now. When you come back, I will ask you that question more generally. I didn't really want to put you on the spot by asking you to explain what happened on that occasion.
Vessels should at all times proceed at a safe speed, that the captain can take proper and effective action to avoid collision and be stopped within a distance appropriate to conditions and circumstances. Even at slow speeds, your boat will create a wake. Look behind at your wake and be aware of the impact this can have on other boats, people in the water, or the shore. Traveling at the speed shown on the speed restriction sign does not guarantee you are not creating excessive wash. When navigating near, in or through a mooring area, drive slowly and keep the wake to a minimum, and keep a lookout for people in the water, small dinghies, and trailing ropes. To determine a safe speed, take the following factors into account: visibility, traffic density, how easy or difficult it is to move the vessel, including stopping distance and turning ability, state of the wind, current, navigational hazards, and draft. It is also important to always keep a lookout to monitor landmarks, navigational hazards, and the captain's blind side. For more information on obtaining a license to fish, contact the Department of Fisheries at 468-4143.
Madam Speaker, you were just about to tell us the reasons or the causes that would make you as Speaker interrupt a member.
Yes, if the member is speaking or has stood on a point of order and the point of order is wrong, there are instances where a member may be on his or her feet and another member interrupts. There are times when that member can yield and take his or her seat, and there are instances, depending on what it is, the member standing does not have to sit and yield to the member who is interrupted. And so you cannot, I ought not, in the conduct of the business of the House, have two members speaking at the same time. So that is one. The other can be a situation where a member is speaking and it is not the member's turn to speak, or the business of the House is such that the House is supposed to go down either to committee stage or to deal with another issue. And the Speaker does have that authority. The Speaker does have the authority to ask a member to take his or her seat, and even when a member may not have done anything wrong, but the Speaker wishes to interject at one point. Once the Speaker puts on her mic, she's supposed to be heard in silence, and so any member who's standing on his or her feet at the time has to take the seat.
Needs to sit. Very good. Yes. You mentioned a while ago that there were 17 members of the House. Are there always 17 members?
Well, what I said was that there were 17, presently there are 17 elected members of the House. However, the composition of the House is such today that there are 19 members of the House of Assembly. The House of Assembly, it may sound surprising to St. Lucians. The Constitution under Section 30 provides that, under Section 32, 30 subsection 2 provides that the Speaker of the House can be elected from outside of the 17 elected members, which is the case with myself. Apart from that, under Section 30, subsection 3 of the Constitution, where the Attorney General is a public officer, the Attorney General is or becomes a member of the House of Assembly. So currently the composition of the House of Assembly is that there are in fact 19 members.
Yes, I think that is a little known fact that the Attorney General is a member of the House.
Let me just add here, Moderator, whilst the Speaker can be in or out, we have never had a speaker from among the elected members. The difficulty that speaker has is that speaker never has a vote. So for example, the President of the Senate does not have an original vote, but the President of the Senate can break a tie. A speaker who is elected outside of the 17 has neither an original vote nor a casting vote.
Okay, thank you. Now, Madam Speaker, back to you. I don't want to monopolize you, but I want to ask you, are there any other officers in the House who assist you with your responsibilities?
Most certainly. There is somebody whom we forget a lot, the Clerk of Parliament and the Deputy. Sometimes both of them sit, and we see them sitting at a lower level, but within the center of the horseshoe of the House. And the clerk carries a very important function, not just in the House during sittings, but actually in the operations and runnings of the office of the Parliament. And she's ably assisted by a deputy clerk, as well as the office of the Parliament has a complement of additional auxiliary staff. As of now, we have the clerk, the deputy clerk, and 8 other members of staff. Also, in the Parliament and sitting in the chamber during chamber sittings, we have a sergeant at arms. And the sergeant at arms carries the mace, who's that officer who carries the mace. Yes.
Okay. Can I ask you to explain what is the mace?
Not the spraying type.
The mace, according to the president, is not the spraying mace. It is this big scepter, gold scepter, which the sergeant at arms carries on his right shoulder. The mace signifies the authority of the crown, or the authority bestowed on the House to pass laws. And it is also the symbol of the authority of, in my case, the Speaker, and in the case of the Senate, the President of the Senate. It is the authority of the presiding officer of the House.
Okay. Mr. Francis, could I ask you at this stage, the clerk, does the Senate have a clerk also?
Well, I'm glad you asked that question, because the Constitution never refers to a clerk of Parliament. There is no such position, really. Section 38 of the Constitution speaks to, because as the Speaker said earlier in the opening remarks, we have a bicameral legislature. And there is this misconception that one sits after the other. The truth of the matter is both houses can sit simultaneously. So that we only have one chamber in St. Lucia is the reason the House might sit at one time and the Senate might sit at a second time. But it could be such an important bill that the President of the Senate could request this office serve as the Senate for a particular day whilst the House is in session. So there is, the Constitution speaks at Section 38 to a clerk of the House and a clerk of the Senate. But it does goes on to say that the two can be held by one person.
The same person.
So there is also the misconception that the Senate sits after the House. There have actually been occasions where bills have been read in the House, in the Senate, and passed first in the Senate and then in the House. The Family Court Bill, for example, went through the Senate first and then the House. The only bill that cannot be introduced in the Senate is a money bill. Every other bill can come to the Senate first.
Well, a little later I'll ask Ms. Jules to tell us more about the process of bills. But I really want to ask the Speaker the question that everybody wants to know.
It certainly is.
Right.
Do you need a deputy?
Oops.
Most certainly.
You said most certainly. Why is that? What makes you say that you require a deputy?
Apart from saying, according to Sparrow, or the famous, a deputy is essential.
Yes.
Well, The Constitution Order of St. Lucia provides for a deputy at section 36. That's number one. This is mirrored or repeated in Standing Order number 3 of the Standing Orders of the House of Assembly. So there is the need for a deputy.
Well, that is when Parliament is first constituted. But what happens when the position of Deputy Speaker becomes vacant? What is the expected timing for a replacement to be named? Or is there an expected timing?
Timing, I guess, we're playing with words. I think that is what has been happening. So the Constitution at section 36(3) provides, and I quote, "When the House first meets after any general election of members and before it proceeds to the dispatch of any other business except for the election of the Speaker, the House shall elect a member of the House who is not of the Cabinet or a parliamentary secretary to be Deputy Speaker of the House. And if," that is the important provision here, "and if the office of Deputy Speaker falls vacant at any time before the next dissolution of Parliament, the House shall, as soon as convenient, elect another member of the House to that office." So we now down to as soon as convenient. And what is as soon as convenient?
How do you go about telling what is as soon as convenient? Who decides?
It's not for me to decide. Remember, I am the Speaker. And I sit and I take my position. One of the things that is on the order paper since there's been no deputy is that always, as soon after prayers have been said, I proceed to asking the composition of the entire House to elect a Deputy Speaker. And Madam Moderator, I must say this. I can only ask the House to elect a Deputy Speaker in accordance with this Constitution, and not just the Constitution. The Standing Order of the House almost mimics to a T the provisions of the Constitution, in that it provides at the first meeting of the House immediately after a general election, or whenever it is necessary for the House to elect a deputy by reason of a vacancy in the office occurring otherwise, as in a vacancy occurring because somebody has vacated the post. Then, so soon as the Speaker has been elected and members have taken their oath or made their affirmation, whatever the case may be, the House shall proceed to the election of one of its own, not being a minister or parliamentary secretary, to be Deputy Speaker.
And would you say that there are any reasons other than just the fact that it appears in the Constitution why a Deputy Speaker is needed? For human reasons, perhaps?
Madam Moderator, I am human. I am a wife. I am a mother. God forbid that there is an emergency or I'm taken ill and a House sitting has been set for a particular day. Does that mean that the business of the House will not, it has to be postponed?
At your convenience.
At my convenience. Well, that is what is happening right now. So, we've been blessed. The situation is such that we've been blessed.
Very well. I'll let upon you at this stage. I'll ask
Thank you.
Mr. Francis instead. Mr. Francis, what is your take on as soon as convenient?
Oh, well, I am diametrically opposite to Madam Speaker. First of all, when one interprets legislation, whether it's the Constitution or statute, the spirit and intent of the Constitution are as important as are the words written. I am not a lawyer, Madam Speaker is. It could not be that the Constitution and the standing orders would place such an important factor on the election of a deputy at the first sitting of Parliament to actually explicitly say in the Constitution that no other business can take place unless the deputy is elected. That is like having a cricket match where there are two umpires, and you're saying it's okay to start the match with two umpires, but one can walk out in the middle of the match and you can continue. You can't. Secondly, you have a situation where the Constitution speaks, or the intent is for an ordinary vacancy. This is a contrived vacancy, where to meet the constitutional requirement of the first sitting, a deputy is elected, promptly resigns, becomes a minister. That's second. The convenient word in the Constitution, the courts have ruled on convenient. The courts have ruled on dispatch. Moreover, if you go to the Interpretation Act, Section 36, subsection 10, it says where a time limit or time frame is not given in any statute, it shall mean immediately and as soon as possible. Don't take my word for it.
Well,
Look
isn't the wording
well,
with
the exact
all
wording is all
convenient
convenient speed and not otherwise.
And
Now,
there we come on the word convenient
No, but
again.
the courts have ruled what is as soon as possible. There's a South African case, it says as soon as possible, 14 days. The Privy Council cases, as soon as possible, 21 days. But here's where I disagree with Madam Speaker.
Well, I'm not sure Madam Speaker has
No.
given a position.
She made a point that she can only ask. I disagree. The Speaker is the ultimate authority in the House. And the Speaker must go beyond asking members to elect a deputy. The Speaker should adjourn the House and no further business if the deputy is not elected. There have been substantive cases where the Speaker, let's look at, for example, 2006. The reverse happened in 2006. The then Prime Minister, Sir John, appointed every member as a cabinet minister or a parliamentary secretary. I gave him a call one day and I brought it to his attention that he has nobody to be a deputy speaker. On the morning of Parliament, the Tuesday, Sir John disappointed one parliamentary secretary and he was appointed deputy. The reverse is happening now.
Okay. Yes, but in your view, the Speaker should adjourn
the House,
the House
because the House is not properly constituted. One understands a minor emergency. One understands something comes up. But the fact of the matter is, again, we have to go on tradition. Whose business is being conducted in the House? Not the opposition business. The agenda in the House is the government's agenda. It is the government that brings bills to Parliament. It is the government that seeks to borrow money. It is the government's agenda. The government must, of necessity then, ensure the House is properly constituted.
But does the Constitution indicate at all whose duty it is to nominate a replacement
Well,
for the deputy
let's
speaker?
go, since we want to talk about what the Constitution says explicitly Let's go to 1982.
Can we stick a pin? When we come back, we will talk about
Yeah, I
1982,
no, I would want to.
because we have to go to a break now, and when we come back, we need to give Miss Vidal-Jules a chance.
Certainly.
Foya, qui ça ou ka fait depuis là?
Moi voulais acheter un soulier sur internet là. Mais l'autre quoi, moi t'ai fait ça. Moi t'ai joué une bagaille la pièce. Moi juste gaspiller l'argent moi.
Ah, eh bien Foya, t'allais la kaini bagay ou ka kouye postcode. So moi quoi ou pas kay ped sous les ou fois ça.
Postcode, ça que ça.
Un postcode, c'est un groupe lettre avec numéro qui ça fait yo savent côté pour mener patché ou les ou poster. Comme ça, un l'autre nom pour postcode, c'est zip code. Postcode qui aide ou joindre sous les ou plus vite. Cité et bien plus pays ni même noir. Postcode là qui aide ces patché à arriver un pays a yo aussi posé arriver.
Moi juste commencé à acheter bagaille sur internet là.
Mais oui, si vous voulez plus d'informations, ou ça couille c'est Lucia Postal Services et qui vous ka aider ou.
Faut à moi aimer ça.
Interpretation.
Yes, Mr. Francis, can you complete that thought that I interrupted you on when we went to the break?
Okay, so we're going to talk about the strict interpretation of the Constitution. Let's go 35 years ago to 1982, where we had a constitutional crisis in that there had been the fall of a government led by Winston Snack, the Chamber of Commerce, the Catholic, there was a body with the religious organizations and the trade unions, the Christian Council, came together at the meeting at the official residence of the Prime Minister, came together and agreed Mikey Pilgrim will be an interim Prime Minister for 6 months. There is no provision in the Constitution of St. Lucia for an interim Prime Minister. There is no provision in the Constitution of St. Lucia for a Prime Minister to be elected other than by the 17 members of the House. But what was important was the continuity of government. Mikey Pilgrim did not, and the record will show it, he did not have the support of the majority of the members of the House. But an agreement which was signed by those parties I spoke of agreed to install Mikey Pilgrim as Prime Minister for the good of the nation. So if we want to talk about the strict interpretation of the Constitution, then we had an extra constitutional Prime Minister for 6 months.
Yes.
Madam Moderator, if I may.
Yes, you may.
Just taken from where former President of the Senate, Francis, spoke as an advising, basically, or he perhaps is advising that had he been in my shoes, he would perhaps,
Absolutely.
this is what he would do. Nonetheless, he's not in mine. The Constitution, I want to make it abundantly clear. The Constitution under Section 35, which speaks to the Speaker of the House, Section 35(3) says, and I quote, no business shall be transacted in the House other than the election of a Speaker at any time when the office of Speaker is vacant. What does that speak to? That the business of the House, once there is a Speaker, can be conducted. Okay? So, whilst I would be the first to say the Constitution provides for a Deputy Speaker and also the Standing Order, I wish to make it abundantly clear that the same Constitution under Section 35(3) specifically states that no business of the House shall be conducted when the office of Speaker is vacant, other than the election, the actual election of the Speaker. So, do we presuppose then that, as I have been doing, that the business of the House can be conducted in the absence of a deputy?
Mm-hmm.
I think this speaks directly to that issue. So, whilst former President Francis is of the opinion that the House may be or ought not to carry on its business without a deputy, I differ based on Section 35(3) 3 of the Constitution.
Thank you. Ultimately, the court may be the final arbiter of that. Now we'll give Ms. Vidal-Jules an opportunity to tell us what is the main purpose of Parliament.
The main purpose of Parliament is stated in Section 40 of the Constitution, and it's basically to make laws for the peace, order, and good government of St. Lucia.
Yes. All right. I want to ask you a little about the process involved in making laws. What prompts the preparation of a bill?
Okay. At the end of each financial year, we normally have a budget in which there is a legislative agenda, which indicates the types of legislation that you would need for the coming year.
Yes.
However, the legislative agenda is not the only means by which legislation is prompted. So during the year, you may have drafting instructions to provide for particular pieces of legislation. Now, drafting instructions can come in many forms. It could come in the form of a cabinet conclusion. Many of our statutory instruments in terms of incentives would come in the form of cabinet conclusions. It could also take the form of a policy document whereby all the elements that are required by the legislation are set out in the policy as well.
So, where is that policy usually prepared?
Well, the ministry who is responsible for the particular area pertaining to the legislation would be the ones to develop the policy.
Okay. Now you mentioned statutory instruments. Can you just give us a little idea, what that is about for those of us who haven't come across that expression before?
Okay, legislation takes two forms. You can either have primary legislation, which would be your bill, which when passed in Parliament becomes an act. And then you have subsidiary legislation, which is, comes in the form of statutory instruments. Now you have different types of statutory instruments. You have regulations, which are very procedural. You could have an order, and you could have rules, bylaws, and notices. All of these are statutory instruments, and they all have different purposes.
Different purposes. So why would rules or regulations be made rather than putting that information into the bill itself?
Because the bill is the primary source of the legislation. And actually, to be able to make subsidiary legislation in the form of statutory instruments, you must have that power coming in your bill.
Okay.
Yes.
For instance, when the bill says that the minister has the power to make regulations in order to put the act into force.
Yes. Statutory instruments, they are supplemental to the bill. So a lot of the procedural requirements would be placed in the statutory instruments so that you wouldn't have a bulky piece of legislation. Because, you could have a bill that deals with many different areas, and if you are to include every single aspect of it, then you will have thousands of pages going on and on. So the statutory instruments are meant to supplement it, and of course you'd have to read those statutory instruments together with the bill, because they are, they become one.
Yes, they read together.
Yes.
Okay. So I want to go through the process. You've said a lot of things, but I want to go through the process to see how a bill arrives on the order paper. First of all, maybe we can start by saying, what is the order paper?
Okay, the order paper is prepared by Parliament, and it usually contains the matters that will be addressed in the House. So if there are motions, they will be present on the order paper, as well as statutory instruments which have to be laid before Parliament. These would be statutory instruments that have already been passed in the Gazette. Also, the bills that are to be considered in the House would also be part of the order paper.
Yes. Who is supposed to decide what appears on the order paper? I know you said it's prepared by Parliament, but how does Parliament know what bills are there to be presented?
Well, when we have drafted the legislation, we would normally submit the bills to Cabinet for approval. Once Cabinet has considered the bill, we would receive a Cabinet conclusion stating that the bill is approved for Parliament. At that point, we would submit the bill to the printery, who would then prepare the 40 copies and submit it to Parliament. When Parliament receives the copies of the bills, that would then inform them of what to include on the order paper in relation to bills.
Okay, so the Parliament ultimately decides what's on the order paper.
Correct, yes.
Maybe I can ask Madam Speaker or former President, does that usually happen?
Okay, ultimately, the Speaker or presiding officer, in the case of the Senate, the President of the Senate, so the presiding officer ultimately is supposed to prepare the order paper. It is prepared at the Parliament office. In reality, this is dictated by the Cabinet of Ministers, who are the ones who control the legislative agenda, as Mrs. Vidal-Jules has indicated. And that occurs not only in St. Lucia, but within our small island states. So really, the legislative agenda is controlled by the Cabinet of Ministers in terms of bills, what motions. So that is at the dictate of the executive, if you want to, for want of a better word, really, because depending on their legislative agenda, what laws they want to pass, the Parliament office receives that, and based on that, the order paper is prepared.
Okay. Now, Ms. Vidal-Jules, you mentioned 40 copies. Why would you have to do 40 copies?
Because some copies are submitted to the House and the others go to the Senate, because the bill has to be read in both houses of Parliament.
Okay, well,
yes,
that must be a very expensive process. I don't think people realize how much paper, how much ink is utilized in just one bill.
Yes.
Okay, well, I would like to ask you, for the people who don't really understand the process of how legislation is made and sometimes criticize the government for not enacting legislation quickly enough, I want you to ask, to help them to understand some of the challenges that may be experienced in bringing legislation to Parliament.
Okay, there's so many. I don't know where to start. I think the most challenging matter that we have to deal with is that when legislation is required, it's normally within a very, very short space of time. Hardly ever are we given sufficient time to properly draft the legislation. So sometimes, for instance, if we're dealing with statutory instruments that are needed frequently, for instance, the price control, we know that the price control is needed for the control of gas prices, and it's needed every month. So we would know that during the month, instructions are going to come. However, we would normally get the instructions on Friday afternoon, and the gas prices would change on the Monday. So normally we get instructions in very, very short periods of time. Sometimes even for Parliament, we may receive instructions a week before. sometimes. It all depends. But that is the most challenging aspect of the job.
Can I ask you, I mean, how long is there a standard amount of time it would take to prepare a bill as opposed to a statutory instrument?
Well, statutory instruments require shorter amounts of time than a bill. But then it's very difficult to answer that question because bills differ in complexity. So you might have a very simple amendment that might not take, very long to draft. But then when you deal with complex legislation, for instance, financial legislation, or legislation that may require a lot more research, because as drafters, you have to be able to draft legislation from many, many different areas.
So you have to be experts in different fields.
Correct. And sometimes you may not have the knowledge on hand to deal with a particular piece of legislation. So it may require you to do a lot of research to be comfortable with the area enough to be able to draft a particular legislation. So it really depends on the level of complexity. And that is not to say that statutory instruments cannot be complex, because there are some statutory instruments that can be very complex as well. So the time differs depending on the level of complexity.
Now you mentioned research and instructions. I mean, how much research can you have to do when it is an area that, you're a lawyer, because suppose it's on finance or engineering, what would you know about that? Wouldn't this come from the instructions?
Well, not necessarily. Sometimes instructions are very vague. You may be submitted with a one-line sentence which just says that you'd like to establish a statutory body, and that would be considered as instructions. So you would have to research, and you would also have to consult with the instructing ministry to then obtain more information that would allow you to properly draft the legislation.
So then the one-line instructions are not the best instructions?
No, they're not.
And you need to send it back when you get the one-line instruction?
Well, we don't send it back. What we sometimes do is, because when you learn legislative drafting, there are certain provisions that are common to certain areas. So if you get a one-liner, you would perhaps try to give the ministry an idea of some of the provisions that would be required under the legislation, and then assist them to assist you in putting together the legislation.
Interesting.
Yes.
All right. Now, all right, you said the challenges. You said there are many. Can you give us any other challenge that you have? The first one you said was short notice.
Yes.
So what else is there that is a challenge to you?
Well, we actually alluded to another challenge when we spoke of the one-liners in terms of drafting instructions. So that is another challenge. Another one that I can think of is response time, because many times we would get instructions that legislation is urgent. We'd prepare it as soon as we get the instructions, and we would submit it to the ministry. And it would take a very long time before the ministry would respond, and sometimes we at the units, we wonder if this was really urgent in the first place. So response time is very, very slow.
Yes, I myself can speak to that, and yes, I think people don't realize that this is holding back the legislation. Well, anyway, we'll take a break right now, and when we come back, you'll tell us a little more about drafting laws.
I'm so fed up with my 14-year-old child. She's driving me crazy. I just don't know what to do.
All that child need is some good licks to wake up.
Alice, ignore the counseling Pansy is giving. Government employees have free access to professional counseling services under the Employee Assistance Program known as EAP.
EAP? EAP? What's that? Not me that telling people my business.
Listen to me, Alice. I was struggling with my child. I made an appointment to see an EAP counselor, and I was very satisfied with the service that I received. And you know what? Up to a day like today, my information remains confidential.
Cox, how come nobody in the office knew anything about your counseling?
That's because EAP counselors, they work under strict clauses of confidentiality. I know you know what confidential means.
EAP providing professional counseling services? How much is it?
Girl, the counseling is free. Free for you, free for your child. And you know what? Your information remains confidential. Call the EAP unit at the Ministry of the Public Service. Telephone number 468-2269 for more information.
EAP works. Let it work for you.
Well, we're actually in question time already. Surprise, surprise. But so while I'm waiting for the audience to ask any questions they wish, maybe I can go back to Miss Jules and ask her a little more about the drafting department. Does your department have any relationship with the AG's chambers, the Attorney General's chambers?
Yes, we are a unit of the Attorney General's chambers. Yes, we are.
And what are the qualifications to be a drafter?
Well, first and foremost, you must be, you must have an LLB and a master's or an equivalent qualification in legislative drafting.
Okay. How many drafters do you have in your office? 5,
including myself.
And what is a day in your office typically like?
Wow. A lot of work, lots and lots of work. Sometimes I go into the office and I don't even achieve the work that I would have put for me to do for the day. Yes.
Yes.
Yeah.
Now, I don't want to stop the audience from asking questions, so anybody can feel free to approach the microphone. But it's just that I had some more information to impart, so I'll keep on speaking to Ms. Jules while waiting for you to approach the microphone. Ms. Jules, there's been a lot of talk about constitutional reform, and I want to know what, if anything, does constitutional reform have to do with enactment of legislation?
Well, as the phrase suggests, constitutional reform requires the amendment of the Constitution. Therefore, if we are amending the Constitution, you would have to have some form of legislation to do that.
Okay. Is it more difficult to amend the Constitution than any other type of legislation?
Yes, it is, because there is a specific procedure that is set out under Section 41 of the Constitution.
Yes.
Yes.
And what does that procedure require?
Okay, it requires for some provisions in the Constitution to be supported by votes of not less than 3/4 of all the members of the House, and in the case of other provisions, for a 2/3 of all the members of the House.
And how is that different from ordinary legislation?
Because with ordinary legislation, you would just use another ordinary piece of legislation to amend that legislation.
And what majority is required in that case?
No, you don't need a majority for ordinary legislation. You would just pass a piece of legislation.
A simple majority.
Well, in the House, when the bill is passed through the 3 stages, yes.
Yes, yes. Let us go back to that special majority, 3/4 or
2/3.
2/3. Mr. Francis, in computing those figures, 3/4 and 2/3, in actual practice, how many people have to support that bill?
Well, 2/3 would be
My math tells me, yes, 12.
And 3/4 would be
maybe 13.
13.
13.
Yes. But that is not required in the Senate.
Yeah.
It's only in the House, because the Constitution speaks to three different types. It speaks to the Parliament when it wants to, and it speaks to the House when it wishes to, and it speaks to the Senate. So those provisions of the 2/3 and 3/4 are to the House. The Senate is a simple majority. And even when there is an amendment to the Constitution, if the Senate amends the amendment, that amendment that goes back to the House requires the same amount of majority, the same majority as the first one, or the House can just simply ignore it.
Yes, no, there's a saying, the ayes have it. How easy do you think it is to get that 3/4 majority in some cases, or 2/3 in other cases?
Unless there is real consensus, because as it is, the composition of the House of Assembly does not lend itself to any party or the governing side or the opposition having that kind of majority. So for example, let's just suppose it was a situation where right now we required a 2/3 majority or a 3/4 majority. There has to be almost consensus on the matter by both bodies, both opposition and the governing side. So you would have to have a vote to achieve that. You would have to have not only, for want of a better word, all the governing side, but members of the opposition as well. So at best, if you have all the governing and all the opposition, this is a fait accompli, and that is the best you can possibly hope for. But to achieve this, save for a situation during the parliamentary term of 1997 to 2001, no one party or no one section of the House of Assembly can achieve this.
Yes,
except for the 2/3. The 2/3 was achieved in 1982 and 2001.
Oh yes.
But nobody is, apart from 97, as the speaker has pointed out, nobody has reached the 3/4 threshold, but the 2/3 has been met 3 times.
This is really the point I want to highlight, that for constitutional amendments, we need this significant majority, and there must be consensus.
Consensus and coming
Yes.
together of the minds. And it would require putting political affiliations aside and what is best.
Okay, I think we have a question from the audience.
Good evening, everybody. Very interesting and informative discussion. I'm Stan Bishop from The Voice. Over the years, we've heard that the Senate has basically been a rubber stamp for the party that would have been in power at the time. We've noticed in the United States, for example, Senate confirmations have been very narrow of late, especially, even though the Republicans have, like, I think, a 2-seat majority in the Senate. But you find in those locales, you find people voting against the party's stance. However, in the case of Simisha, we've always noticed that the eyes always have it for the guys who were in office at the time in both houses. Any particular reason for that? Is there some kind of... do you think the members fear backlash for doing such?
During my tenure as President of the Senate, we will recall that Mr. Francis spoke earlier and said that with respect to the Senate, the President has a casting vote. In the House of Assembly, in my case, where I'm not an elected parliamentarian, I do not have a casting vote. In the Senate, when I served as President of the Senate, I remember that there was a situation where there was a tie, and I had to cast a vote as a tiebreaker. Now, I remember specifically a senator from the opposition then actually alleging that he knows where I would vote because I would vote for the for the governing side. And I took strong objection or offense to it, really, because the idea is I was president of the Senate, and that required me to have a vote. And for me, I would vote my conscience and what I felt was correct. And I think at that time, it had nothing to do with party sides for me. There is a piece of legislation, and I looked at it, I read it, and I had a vote to cast, and so I casted it. So I took strong objection to a member, a senator, saying that he knows how I will vote because I'm on the governing side. And I think such impressions, rubber stamping and all of that, it's almost sometimes, people don't realize how perhaps insulting some of these things are when you say things like that. Because it's, as a person, you would have a stand on a matter. And as a presiding officer and with a casting vote, you would vote your conscience on what you feel.
Stan, but there were several faulty premises to your presentation. The first is the comparison with the United States. That's a faulty premise. The United States senators are directly elected by the people for 6 years. So that's one. Secondly, the small size of St. Lucia's parliament makes it nearly impossible for members to vote against the party. And I'll tell you why. It doesn't matter who is in the government, the United Workers' Party or the St. Lucia Labour Party. As the speaker said earlier on, legislation is generated by the cabinet, the executive. Who forms the executive? All of the members on the governing side form the executive. They would have discussed the bill in cabinet. There is the doctrine of collectivity of cabinet. Once the bill leaves cabinet and goes to the House, there is a presumption that the cabinet has collectively agreed to the bill. So the member for District A cannot, having been a cabinet member who has supported the bill in cabinet, come to the parliament and vote against it. So the small size of our parliament prevents, and I think whoever has been presiding officer on any party will tell you, not just St. Lucia, the small size of the cabinets in the OECS especially prevents proper debate in either chamber. Because you have to debate what you agreed in the cabinet. Otherwise, if you disagree, because cabinet doesn't, unlike the House, where the speaker puts the question, in the cabinet, it is agreed or not agreed. There is no vote of numbers. So you don't know how many, you just know it has been passed. But once it's been passed, whether by one person or not, everybody adopts it. You cannot now come into the House and rail against it. So bear in mind that to be a minister, you must be a parliamentarian. Where does your loyalty lie? To the district that put you in parliament to make you a minister, or to the prime minister who makes you a minister? It's a tough call, and the fact is you are bound by cabinet collectivity. So, like the speaker, when I hear members of the public say these things about people are biased and people like that, none of them have read the standing orders. None of them know what's happening. They just assume because the speaker is the speaker in the United Workers' Party-led government, then she's biased towards the government. But that's not always the case. If you're going to make a statement that somebody is biased, take the standing orders and show where she's gone wrong, show where she is ruled contrary to it. But don't say because the person has voted. You know, we go back to the question that was asked by the moderator. They say she asked the prime minister to sit. That's another fallacy. In the House of Assembly, the prime minister is the prime minister only when he's presenting the bill. Other than that, he's the member from Mico South, just another member. But nobody will tell you she asked another member to sit. the CC as a prime minister because it sounds more ferocious.
All right, Mr. Francis, just let's take this other question before we go to the break so that when we come back, we can answer it. Yes, sir.
Good evening. Very interesting conversation and discourse tonight. Jeshua and Andrew, youth advocate. My question is that as a nation moving forward, we want to help the youth feel like they could be more involved in the affairs of the country. And if a group of young persons have a law that they think is necessary, that should be passed in our nation, can you tell them what is the process, what is necessary to do so, to achieve that? How can this be done?
That's a good question.
Very good question. Can I just start with me?
Can you say it after the break?
Yes, well, yes, I think we have a few more seconds, so Ms. Vidal-Jules, could you start? How? Well, anyway, we'll take a break now. When we come back, we'll take that answer.
La main propre, c'est chemin bonne santé. Il est absolument nécessaire pour laver la main si vous voulez une bonne santé. Quand même, si vous prenez de l'eau citerne, vous ça fait ces bagailles là. Écoutez, lavez la main souvent et puis l'eau nette avec savon, après condition qui a 6 mains 20 minutes. Par exemple, on pour laver la main après vous changer d'arrière-part, servir très vite, occuper les gens qui sont blessés et bien malades. Après vous occuper les animaux et après vous entamer les ordines. Et si vous prenez de l'eau, vous ça servir ça yo kakouye hand sanitizer et bien alcool pour 30 secondes. Lavez les mains souvent. Ça c'est une manière pour empêcher maladie. Si vous voulez plus d'informations, priez Bureau Information Santé à numéro 468-5349.
Yes, the question when we took the break was basically how do a group of young people put an idea that they have into legislation? How do they get a bill before the Parliament? Ms. Vidal-Jules, can you tell them?
Well, in terms of the actual drafting of the bill, I would think that they would need assistance from the legislative drafting unit in terms of the actual preparation of the bill. Once the bill is prepared, I think there is a process in Parliament where you can have a private member's bill and it can be introduced in Parliament and passed.
Taking on from where Ms. Vidal-Jules left off, I would say to Joshua, is it? Joshua. That a group of young people sufficiently interested in a specific area, there is no legislation that you know of. You get involved to the extent that you say, well, how is this going to benefit your group? Create awareness of it, and from there, so you have an idea as to what it is you want, how it is going to redound to the benefit of general young people in St. Lucia. And what you can do is, okay, should I go back and say, most bills are introduced in St. Lucia and discussed as we've discussed through cabinet. However, that is not the only way bills can be introduced. So for example, at the cabinet level, if it is a bill that affects sports young people, it goes through the Ministry of Youth and Sports and that kind of thing. There is the alternative of introducing what we call a private member's bill. So a member any member in the House of Assembly who's not a minister or a parliamentary secretary is what you would deem a private member. In our case, what we have are 6 opposition members. And through them, they can be the pioneers of a bill. And coming through them, it becomes a private member's bill because they are presenting the bill on behalf of the interested group, not coming from the cabinet level through a minister under a ministerial portfolio. However, that being said, you would definitely need the assistance perhaps of a lawyer, perhaps for starting off with it, an attorney, and then the able assistance of the best that we've got would be the legislative department of the government. But it can be done without going through the cabinet of ministers and coming under ministerial portfolio. it is permissible for a member known as a private member, not being or not holding a ministerial portfolio, to present a bill in the House of Assembly.
And Mr. Francis?
I would only add that the Speaker is absolutely correct on all the points she's made, except, and that's where constitutional reform comes in, under our current laws, it is prohibitively expensive for a private member's bill, because a private member under our laws has to make the 40 copies that Ms. Vidal-Jules spoke about from his or own pocket. His or her own pocket. He has to print those 40 copies. Give it to them. If amendments are made, he has to go back and print those amendments in new copies. 40 bills are not cheap. And that is where, so whereas the law gives you an avenue, the financial constraints are overwhelming, and the best bet would be the first option that Madam Speaker spoke about, which is to go through a ministry or a department. Yeah. But she's absolutely correct, you can go through a private member's bill.
And Mr. Francis, didn't you already say that a bill can originate in the Senate?
In the Senate, but you will still have to go through the same process. But more specifically to your comment, and Madam Speaker alluded to it very well, the awareness. The family court didn't come out of any governmental organization saying, we need another court here. It came out because the women's groups were saying, it takes too long to get redress. It takes too long to do this. The commercial court, which was just recently enacted, didn't come out because some minister or member of parliament decided. It was because the business community was saying, we're taking too long. There's sometimes a small claims court, all of those. In Jamaica, the gun court. Sometimes necessity pushes those things forward. So if you follow the Speaker's advice, bring the awareness, other people, in fact, you'd find a minister coming to you to make it his idea.
That's true.
I want to backtrack here just a little bit to mention the referendum. This is, maybe you can tell us, Ms. Jules, about the need for a referendum. When do you need a referendum?
Well, earlier we spoke about amending the Constitution and having a special provision. So it is under Section 41 that a referendum is required when any provisions in the Constitution, are being amended.
Okay, so after we get the special majority in the House, then we go to the Senate, and it's just a simple majority there, and then we have to go to a referendum.
Yes.
Okay. Mr. Francis, do you think for constitutional reform, once the bill passes through the House and the Senate, that success on a referendum is guaranteed?
Oh, on the contrary. To the contrary. In fact, it's a funny thing you hear, and I don't know what Madam Speaker's view, that you hear people talk about politicians and parliamentarians trying to think for people. Let's look at the most recent referendum in the Caribbean. Grenada. On the subject of referendum was one question to give women equal rights as men. Another question was to give children born out of wedlock the same rights as children born within the marriage. Overwhelmingly passed in the House because the government has all the seats. Overwhelmingly rejected by the electorate. And you would think, what sort of society would not want equality between men and women? What sort of society would not want every child to have the same rights? A guy strays and has an extramarital relationship and a child is born, and that child must suffer in law for that, and you have the society saying, yeah, let's make the child be punished a little more. So no, it's not guaranteed at all. And then when people talk about politicians, politicians get a bad rap. Sometimes politicians actually mean well and the population turn against them.
There is a good element of control in that. With respect to referendum in the Caribbean, the situation in this is Grenada, where the entire composition of the government. I mean, St. Lucia, we had a 16-1. Grenada is a clean sweep.
15.
Okay? It's the same people who elected them. They passed this, and then they rejected it overwhelmingly. So the people still do have, they still do have the control.
Well, I'm glad you all are saying that, because with my task in constitutional reform, I like to, you know, get the idea out that constitutional reform isn't to be taken for granted.
That's not easy.
And the fact that it passes in the House doesn't mean that the electorate will support it. Mr. Francis, with 270 recommendations for constitutional reform, how do you foresee that task being done? What success do you anticipate?
I don't, because when one looks at the 270 recommendations, we call them recommendations, but they are largely ideas brought up by sectors. So for example, one of the ideas brought up is that each district, let's say Babylon, 2 people run for each party. A primary person whose name is in the ballot and a secondary person. And the idea is, if the Prime Minister chooses the primary person to be a cabinet minister, then the secondary person becomes the member of parliament. But if the Prime Minister fires the man tomorrow, what then? He got elected. He's going to be a minister at the whims of the Prime Minister. The second person, who didn't feature at all in the election, is now the member for parliament for Babylon. But the Prime Minister is not satisfied with how that person performs and dismisses that person a month later. He can't go back to his seat. He's lost that seat to the person who was never. So I don't know that these are recommendations per se, as they are ideas that came out of discussions throughout the country. And I think they're so varied in nature, they cannot be done simultaneously. It has to be done over time.
Well, on that point, I noticed that our time is running out, so it's only left for me to thank you sincerely for your generosity in giving your time to perform this important task in educating the public. And to recap a bit, we have learned a lot about the significance of Parliament, MPs, senators, officers of Parliament, such as the Speaker, the President, the important topic of Deputy Speaker, which I noticed none of the audience asked about.
Madam Speaker dealt with it.
We found out about Parliament's important function in making laws, and I'm sure it's possibly more intricate than people may have realized, and more costly and more time-consuming. So I hope that at the end of today's discourse, everybody has at least a little idea about how this important part of our everyday society is occurring, and we see the people who make it happen, and we thank them sincerely for their contribution. And on that note, I'll say good night.
Thank you very much.
It was a pleasure being here.
Need you to understand, I am a St. Lucia, no matter how far I go. Thank God that I am a St. Lucian, and I come from the land of sun.